Ready, start. The deceased was admitted in the hospital with about 60% burn injuries and during the course of treatment developed septicemia, which was the main cause of death of the deceased. Full stop. It is, therefore, established that during the aforesaid period of 8 days, the injuries aggravated and worsened to the extent that it led to ripening of the injuries and the deceased died due to poisonous effect of the injuries. Full stop. It is established from the dying declaration of the deceased that she was living separately from her mother-in-law, the appellant herein, for many years, and that on the day in question she had a quarrel with the appellant at her house. Full stop. It is also clear from the evidence on record that immediately after the quarrel, she along with her daughter came to fetch water, and when she was returning, the appellant came and threw a burning tonsil on the clothes of the deceased. Full stop. Since the deceased was wearing a terylene cloth at that relevant point of time, it aggravated the fire which caused the burn injuries. Full stop. There is also evidence on record to prove and establish that the action of the appellant to throw the burning tonsil was preceded by a quarrel between the deceased and the appellant. Full stop. From the aforesaid evidence on record, it cannot be said that the appellant had the intention that such action on her part would cause the death or such bodily injury to the deceased, which was sufficient in the ordinary course of nature to cause the death of the deceased. Full stop. Therefore, in our considered opinion, the case cannot be said to be covered under clause within bracket 4 of section 300 of IPC. Full stop. We are, however, of the considered opinion that the case of the appellant is covered under section 304 part 2nd of IPC. Full stop. In the present case, we have come to the irresistible conclusion that the role of the appellants is clear from the dying declaration and other records. Full stop. However, the point which has also weighed with this court are that the deceased had survived for around 30 days in the hospital and that his condition worsened after 5 days and ultimately died of septicemia. Full stop. In fact, he had sustained about 35% burns. Full stop. In that view of the matter, we are of the opinion that the conviction of the appellants under section 302 of Indian Penal Code is required to be converted to that under section 304 within bracket first of Indian Penal Code, and in view of the same, appeal is partly allowed. Full stop. The conviction of the appellants original accused under section 302 of Indian Penal Code, White Judgment and Order dated 19/12/2007, arising from Sessions Case number 149 of 2007, passed by the Additional Sessions Judge, Fast Track Court number 6, Ahmedabad, is converted to conviction under section 304 within bracket part first bracket close of Indian Penal Code. Full stop. However, the conviction of the appellants original accused under section 452 of Indian Penal Code is upheld. Full stop. The appellants original accused are ordered to undergo rigorous imprisonment. Full stop.